falling behind on bills is stressful enough. When a debt collector adds to your burden by contacting your employer or other people where you work without permission, it really can feel humiliating and even threaten your job security. This kind of harassment is not only embarrassing, but can actively harm your reputation. The good news is you have legal rights. If a debt collector has been contacting your employer without your consent, you may have an FDCPA case against that. Ideally, for these claims, there's a couple conditions that we'd like to apply. Not necessarily always the case, but if these two conditions are present, then it's a good chance it's a good case. The first one is the company needs to be a legitimate debt collector. It's some scammer really working out of his mom's basement. Those are tough, right? They're tough to get them served. If they're overseas in another country, tough to find them, tough to get them served, almost impossible. The best you can do is do a law enforcement claim against them, and generally speaking, they don't go anywhere. So scammers don't really count. If we can't serve them, they don't have any money, so it's not that punished. Also, it's really helpful if there's not an existing court judgment against you in favor of the particular debt collector or creditor, if they collect on behalf of the creditor. If there is a judgment, there are instances where they can contact your employer to effectuate employee punishment, potentially depending on the state you're in, and maybe to research and see if you have assets, depending on the state, depending on the rules on that state, which is why it's really important to get a lawyer and try to handle the case before a judgment is entered against you. Once it's entered against you, they can't talk about anything. They can't all say nasty things about you and then try to embarrass you. They can really just focus on the limited things they're allowed to do. So if those two conditions exist, if it's not a scammer and there's no judgment against you and they're contacting your employer or people at work, and beyond just asking for location and corrections, there's a few minor things they can reach out and then try to get, but they're actively claiming that you've got a debt, you have to pay your bills, things like that. There's some things we can do. We can force them to, or court can force them either to cease this harassment, stop doing it. We can possibly get you some money. You can get money for legal damages, repayment of any wages if you lost due to a situation you couldn't work because of the stress, the harassment, and you got fired. Those can be damaged. Any mental distress you have, that can be actual damage as well. You won't get rich, generally speaking, on the FDCPA claim, unless there's significant actual damages, such as you getting fired or losing time off work. But the best part is you don't have to pay for any legal fees, at least up front. The law requires that if you're successful, that there's a debt collector and they violate the FDCPA, they have to cover your attorney's costs, which is your fees and the cost of filing suit if you win the case. So most of us take these cases on contingency matters or contingency basis, much like a car wreck or something like that. Sometimes the pay structure is a little different, but it's almost always the contingency basis. So you're not required to come up with that money first. If all, if you're successful, then either the court will tell them to pay our fees, or they'll settle and we'll take our fee out, whatever the settlement amount is. But if you have any questions about this issue or any consumer protection matter, we're happy to help. Give us a call. Reach out to us at cliffcrossinglaw.com.